verbally today at the meeting.
All right, thank you so much, SG. So we'll go now to the technical team to go through the documents and all the outstanding or carryover issues.
Thank you, Chair. Good morning, everyone. We will go to the document that indicates the responses to some queries on the draft Teaching Council bill. It was compiled based on discussions as a technical team. The first one on the list was to consider whether it is appropriate to replace the word child with the word student in light of the term best interests of the child. And we also note that child is used in the definition of approved home education program under the bill. The response is, upon a review of the draft bill, the ministry did not see the need to replace either terms based on the context within which they were used in the bill. However, in light of the definition of a child, the best interests of the child would not capture all students. And the proposal of the ministry is for consideration to include the best interests of the student where appropriate, noting the vulnerability of the group in the teaching and learning context. And this is an issue that we referred to the Attorney General's chambers for consideration as to whether best interests of the student can be incorporated in the bill. So based on Madam SG's response just now, I would like to ask through you, Chair, if the chambers could respond to this proposal.
Before we go to the chambers, you started out by saying that the ministry did not see the need to replace either term based on the context within which they were used. And then you said you'd replace. Seems a little contrary.
Okay, so we looked at the bill and the terms child and student were used in different instances. So when we looked at the different instances in which each term was used, we didn't see the need to change child to student or student to child in each case. However, because there's a term of art that is used in the bill, which is the best interests of the child, which is defined under the Child Care and Protection Act, the child definition for child would not capture a student, because a child, as we know, is based on the definition is up to 18 years. But a student can go over 18 years old. So what our concern was is we need to cater for the best interests of a student as well. But the best interest of a child wouldn't cover best interest of a student.
So the bill would still use all those terms within it.
Right.
The best interest of a child, best interest of a student.
There is no best interest of the student, no. So that is why we want the chambers' input.
Sorry. Minister, before the SG responds, may I just ask a question? If the word student covers all children, but the word children does not cover all students, what is the resistance to just using the word student versus using both? I'm just curious as to what's the logic behind that. Because all student would cover all children. In the system, yes. In the system, yes, it would.
Let me offer, because what was mentioned was the context in the areas of the bill that refers to a child. Right. So we may have to look at that context where the child is applicable, and we want to protect the interest of the child.
Which is covered by the word students as well. Because all students in the education system, all children in the education system.
Yeah, but suppose there's an area that has a student, but it does not cover
Such
the
as?
interest of the child. I don't know, I'm just applying it where the context of what is represented in the bill might speak to a child as opposed to students.
I can't think of any, so if someone can think of any, but because all children are students within the context of this bill, but not all students are children.
All
So
right,
to prevent...
Let's go to the AG.
Just to indicate, though, Chair, that at clause 5 of the bill, it says, a person shall, in the exercise of the functions of that person under this act, regard the best interests of the child as the paramount consideration. And under the definition section of the bill, it defines what best interests of the child is. And it says it shall be construed in accordance with Section 2, subsection 2 of the Child Care and Protection Act. And the Child Care and Protection Act, it lists the things that are to be considered as the best interest of a child.
And I understand that, but because we have a sixth form program now, where chances are you will have students over the age of 18. Are you saying then, because you are just supporting my point here with what you have pointed out, the Child Care and Protection Act goes up to age 18, unless I'm wrong. It goes up to 18. What happens to, or 16? What happens to our sixth formers? They're not children by the definition in the Protection Act. So that's why I'm saying, why not use the word that would cover them all?
So,
Could we?
Chair,
Yeah.
there's a kind of middle ground that I'm getting here, because what Senator Rodriguez is saying makes sense in terms of those students who are above 18 years old. But the proposal to include best interest of the student, I think, would solve the problem, because the child is a subset of student. So if we put best interest of the student, it would cover both the best interest of the child plus the best interest of the student. However, I do think that in this instance, we don't need to use the term child.
I'd love to hear from the AG on this, please, since it was sent. I'm sorry, the SG, because it was sent to the AGC.
Okay, thank you, Chair. Well, honestly, a lot of that is policy. We have to decide what terminology you want to use that you think best suits the interests in your legislation. Our only input is to say that we do not support a wholesale use of the term, using the definition best interest of the child and just simply removing child and putting student for the following reason. The definition crafted in Section 2.2 of the Child Care and Protection Act that deals with the best interest of the child was a treaty obligation. We were implementing the Convention on the Rights of the Child, and the crafting of that provision is specific to persons who are under 18. So it looks at things like sufficient age and maturity. And this is necessary because you will note, and your members would note, that a child is not always afforded the same rights and protections that an adult is. Again, due to things like their age and maturity. And so that definition is specifically crafted to persons who are under 18. Whereas I don't have a difficulty with you using the term student once there's a careful review of all the places that the word child is used, and you ensure that it is appropriate in all those instances to replace it with student. We wouldn't have a difficulty with that. We would have no difficulty with you coining a term, best interest of the student, but you would then have to do your own definition, because parts of the definition in the Child Care and Protection Act would not be applicable to a person who is over 18.
So, Madam Chair, I think, thank you, SG. And I don't see a problem with doing what the SG is recommending. So, for example, under Section 5 that we spoke about, where it's there to meet treaty obligations, just create a subsection underneath it and say best interest of the student as well, and then define it around the front section where the definitions are. But I do still believe that everywhere else in this bill that we talk about child, we need to replace it with student to ensure that our sixth formers are covered.
Instead of replacing, though, include, this is what the legal team is saying, to use it, because there is a specific definition of,
thank you,
in the best interest of the child.
Right, which is under Section 5. So what I understood her to say is specific to Section 5, and I stand to be corrected, and if I'm to be corrected, I would love if she could do that. She's saying that Section 5 is to meet a treaty obligation, where we talk about the best interest of the child. But elsewhere in the bill, there's no need to use the word child. I don't know if I got her wrong.
Right. No, what I heard her say, she's online, that that she has no problem including as well the best interest of the student, but she would not support a wholesale change of removal of best interest of the child because of how that definition and that it's so embedded in the CCPA, Child Care and Protection Act. SG?
Yes, correct. So what's in Section 5, and if you go from Section 5 to the definition of best interest of the child, which refers you to Section 2.2 of the Child Care and Protection Act, that's a treaty obligation. It's a treaty obligation that that Jamaica has taken very seriously, that we protect the interests of children. I am saying if the committee is of the view that you want to go further to be able to afford protections to those over 18, you could coin a term. It's still a drafting issue because it depends on how many instances you would need to use the term, but you could coin your term and you could define it. I'm just saying you can't use the exact definition for best interest of the child and use that as best interest of the student. It's not simply to take out child and replace it with student. I also have another view, which is there are, as I'd said before, adults are afforded way more protections than children are. And that was the entire reason why the convention, and there was an agreement with 100 and odd states to say that we have to now protect children, and we have come up with this scheme where we talk about the best interest of the child. Adults, persons 18 and over, already are afforded certain protections. It's easier for them to challenge decisions, get decisions heard, because when you're looking at best interest of the child, from my perspective, at least from the legal perspective, we're looking at how decisions are taken against these students who are 18 and over, how they are implemented, whether they can be challenged. Persons over 18 already are afforded those sorts of protections, and the Wensbury's reasonableness, a civil law, principle of law, it says that all decision makers are to act reasonably and with fairness. However, if the committee is of the view that additional protections need to be afforded to these students who are 18 and over, then you can certainly just go ahead and include it in the bill. I think it would be left to the draft to decide whether you really need to coin a term or you just insert those protections in, let's say, a clause where you say students of 18 and over, these are the certain types of protections that you would be afforded.
Or just, yes, okay. Mrs. Gordon-Jones, just for accuracy, is the age that we're talking about 16 or 18? in the CCPA.
It's 18, Chair. It is 18. 18 and over.
All right, so members, I think we are agreed that we can include in the bill, in the best interest of the student, in addition to utilizing in the best interest of the child.
May I ask a question?
Sure.
Of the legal team? Well, based on the suggestion that was just made, whether we'll just put a one clause that will cover it in general, or we'll go about changing it everywhere. I like the idea of the one clause, but I stand to be guided by the legal team.
Madam Chairman, through you, I appreciate what the SG said at the final words she gave. I think it would be better to include in the bill those additional protection for students who are 18 and over, rather than putting in the term best interest of the student, because student is used 10 times in the bill, and at certain, there may be a little bit of confusion when you say best interest of the student, and then you seek to incorporate 2.2 from the Child Care and Protection Act, all those things which apply to a child as opposed to a student who is over 18. It might create some amount of confusion. So I think it is better to outline those additional protection for those students 18 and over, rather than to use that new term. You mean at this point in time? Yes, certainly, on the next occasion. Right. Yes.
You're saying that a one clause can capture that for the protection of students, rather than to be replacing it everywhere that students is applicable.
Yeah, I think it is better to attempt to do that, rather than coining this new term, considering that the other term is a term of art. It's a term that is used in other pieces of legislation, and it may cause some, yes, it may.
All right, I think Member Brown had his hand up.
That is correct.
Okay, go ahead, please, Member Brown.
But I got bounced off. I'm not sure the matter was resolved. But in this legislation, at page 3, there's a specific definition of child. And all we need to do, it says child means a person who has not attained the age of 8. So all we need to do is to shift that to 20 in this legislation. For purpose of this legislation, to capture the students up to 20. And we don't need to get into best interest of child, best interest of student, because it will be defined in this legislation. That's what I wanted to suggest.
Okay, Member Brown.
But as I say, I got bounced off. I'm not sure.
Member Brown, I think you missed the discussion. When you dropped off, I think where we are now is that we are going to retain the best interest of the child, because that is embedded in the Child Care and Protection Act. And it's also international. It's also in international treaties. Where we are as well is that we may not want to coin an additional phrase or terminology here, right? This is Ms. Sherlin. I think that's what I'm hearing from you, that we might not want to coin a different term.
Chairman,
So
I wasn't proposing a terminology. I'm simply saying that on page 3 in the definition, a child goes up to age 18. It need not be for this bill. We could say 20 in this bill.
All right.
So we keep all that is there except for 18 years to be 20 years. And we'll capture what we want.
All right, Ms. Charlene, could you just state again for the interest?
Well, Madam Chair, I think it's also important for Senator Brown to be aware that the word child is defined internationally in many treaties and in local legislation. This committee cannot change the definition of the word child. It is not something that is going to happen. So, I mean, Mrs. Sherlon can explain what it is that we're proposed to do instead, but we cannot change the definition of the word child.
Sir, I beg to differ with Senator Rodriguez, but because as a committee member, the committee is due to make a recommendation, and I don't think it offends international treaties or so forth. But that's my recommendation, and I stand by it.
Okay. Ms. Sherlon, could you go through again explaining, and I know Mr. Brown, you probably missed what the SG had explained as well. So let's just summarize.
Yes, just to summarize, I think we should attempt to include in this bill the extra protection for students who are 18 and over. So we are guided by the protection for children, which is outlined in Section 2.2 of the Child Care and Protection Act. And that will give us an idea of what additional protection we could include in our bill to cover those students who are 18 and over. I think we should attempt to do that and see how that can be included nicely in our bill. And I undertake to do a draft for the next occasion to see how it could possibly work.
Chairman, I am there with Mrs. Sherlon. I will await the draft. Let us move on.
All right. Okay, members. We'll carry on, Ms. Sherlon.
The second on the list of responses, it said the ministry needs to consider whether in defining the word paraprofessional, should this word include all the persons specified in paragraph B of the definition of teach, that is a teacher's aide, a teacher's assistant, a student enrolled in a teacher preparation course, and a person employed or engaged to provide care at an early childhood institution. So the technical team came up with a definition for paraprofessional, and the proposed definition is as follows: a teacher's aide or teacher's assistant who, under the supervision and direction of a licensed teacher or a person who has been granted an authorization to teach under this act, provides care for students. B, a person employed or engaged to provide care at an early childhood institution but who is not employed or engaged to teach at that institution. And C, a person who provides a service specified in the second schedule who supports the teaching, I think that should say the teaching process as per schedule, as per the second schedule. So it said who supports teaching. So the word teaching was inadvertently left off of the definition. So just to note that who supports teaching. So just to note that some of this wording came from the definition of teach at B. So if you go to the definition at B for teach, you would see 1A under the definition for paraprofessional is taken from Roman numeral 1, and B is taken from Roman numeral 3, and C would have been inserted based on the second schedule.
Are you proposing to separate what's here, to make a different definition, to make paraprofessional
So paraprofessional would be
its own
included.
definition, or
It
to
would-
be included?
It would have to be amended somewhat at B. So B would be amended to say does not include duties of the kind undertaken by a paraprofessional, and then we will keep Roman numeral 2 and Roman numeral 4 for the what it does not include for teach. And then paraprofessional will be defined elsewhere.
Yeah. So we're agreeing. Members, I just need confirmation. We're agreeing to add paraprofessional under the definition of teach under section B, and then to define what paraprofessional is. Okay. All right, we'll accept. Members? All right, so moved. Please carry on item number 3.
Chair, for item number 3, I'll allow Dr. Gordon to read that one, seeing that she would have to explain the ministry's position in terms of practice as a teacher.
Thank you. Good morning, everyone. Sorry to be late. The committee asked the technical team. The committee asked the technical team to consider whether the word teach should be substituted for the term practice as a teacher. It's used in several clauses, as you see there. On the initial examination of how the term practice as a teacher is used, it appears that teach could be substituted, therefore. However, on my research on the use of the term, I found out that it is really a derivative from a Latin term. I don't know how good my Latin is, but it's jucere in usu est magister. It means that it is to conduct the practice as a teacher. And what I also found out is that the practice is used in trades. You practice as an engineer, practice as a teacher, practice as a doctor. Yes.
Can you explain, Member Hamilton?
I'm just saying that we have to now just appreciate that there is a practice in the teaching profession, just as there is a practice in law. I think it's the same principle. That is being,
Principle. Practice.
right, practice with a C.
Yes.
Right.
So that makes the distinction.
So
That
this
is a
will
trade
also help to lift
term.
the teaching profession by the use of the term practice. With us.
With a C. It's just that we don't say to conduct the practice anymore. We have cut it short and say practice our teacher.
So with an attorney, we define what we do as a practice, the practice of law, practice with a C. Initially, when I had read through this legislation, I thought it was intended to be practice with an S, a verb. But based on what is being explained to us, it is now being accepted that practice with the C, the noun, is applicable to the teaching profession, which I think will lift the standard of the profession altogether.
to trades.
It is applicable to trades.
Yes.
Chair, I agree because, you know, when I thought about the practice with the S, it's like you're playing a sport and you practice to develop. In this case, it assumes that you have attained some level of development, and so you are part of a practice.
A practice.
Right.
And so you have a law practice, you have a doctor's practice, and even pharmacists practice. So the teachers now who have attained that level of development is part of our practice. Right. With a C. And that's the distinction.
All right, thank you so much, Member Hamilton, for raising that very fine distinction between a C and an S. No, but it's an important one, yes, yes. All right, so we will... Oh, okay, SG?
Thank you, Chair. I apologize. I would like if the committee can recommit the second issue, if you have concluded on the third issue. The number 2, dealing with paraprofessional. So
please go ahead, SG.
It seems as if the committee has agreed to include a definition. Where would the definition be used? And also, it seems as if now, rather than excluding persons like teachers' aides and teachers' assistants, they will now be included. What is the criteria? How do you know you qualify to be a teacher's aide or a teacher's assistant? What are those criteria? It's not very clear to me, nor to Mr. Foreman.
But I think, what page is it again? Page 11. On page 11 of the bill is where the word first is used. Yes. It's there in the bill on page 11, which is, yes, section G on page 11. But I think we don't have to set the standards for paraprofessionals in this committee for this bill. I think that's something that either the Ministry of Education or the Council itself will do. I don't think it's the place of this committee to do that. That is something either the Ministry or the Council will do. I don't know what Dr. Winsome, I don't know, Madam Chair.
Sorry, can I then just clarify to respond to the member? It's just that it was an exclusionary provision before when we referred to teacher's aide and teacher's assistant. We're now bringing them in. So we're no longer excluding them, we're bringing them in. Under the definition of teach, they were excluded. Under this new definition of paraprofessional, we are including the teacher's aide and teacher's assistant. There has to be some power given to ensure that we know what the criterion is. So you may not want to put it in the bill, but because we are now changing how we're treating them, there has to be some explanation of who these persons are. And
can you explain to me, sorry, they were there on page 7 before.
But it said it does not include. It said does not include, so it excluded. It said it does not include the duties undertaken by these persons. Now we're saying we're going to be including them in this definition of paraprofessional. So because it was exclusionary, we wouldn't have raised an issue with the fact that there was no clear guidance about who they are. But now that they are now being brought under the remit of the bill, it has to be clear.
But
whether
SG,
it is in the bill or elsewhere.
SG,
go ahead, member,
on page 11,
Member Hamilton.
It says the council may at G provide services to recognized associations of professionals and paraprofessionals working in schools, which means it is included, no, it is included at that section. And that is why we had a problem identifying who these paraprofessionals were, which is why we came up with this definition, because we didn't know.
Right, I'm not taking issue with the definition itself. I'm saying that you're now including some very
The legislation already included them, we didn't.
It didn't though. It never said who they are, and you are now specifying who they are.
Well,
And that's
so are you saying that we should allow the council to define who paraprofessionals are and leave it as is in the legislation undefined?
No, that's not what I'm saying. I'm saying there should be something in the bill that would explain whether in the bill or in regulations, the criteria for being a teacher's aide, for being considered a teacher's assistant, because you're going to use these very specific terms. So just as how the committee recognized that the term paraprofessional should be defined, the fact that you're now going to be going ahead and including a set of persons, who is a teacher's aide? Who is a teacher's assistant? Is there a difference? What makes there, how do you know the difference? And I'm saying there needs to be something in the bill that will, either in the bill or regulations or an enabling provision in the bill that will further explain this. Because we have explained all the other, or at least we are trying to explain all the other terms that are being used.
So SG, just for clarification, you're saying paraprofessional should be defined in the bill?
No, I'm not speaking of the, what I'm saying, I'm actually looking at the terms teacher's aide and teacher's assistant. How do we know what they are?
Sorry, SG, just so that I can understand from your perspective, why is it wrong to ask the teaching council to define it?
I'm not saying it's wrong. I'm saying I don't know that they have been given that power.
Because I think it would be best.
So we're making reference to paraprofessionals, teachers' aides, teachers' assistants, but thinking that the council probably should define who these persons are, but not giving them the authority in the legislation to do so.
I'm not sure that, I don't know that 11.2G does that. If you're going to split out and not only refer to paraprofessionals, but teachers' aides and teachers' assistants. It says recognize their services, but who are they? How do you determine who they are? That's not done in the definition. You'd have to give a power. And I'm saying I don't see it. It may be there, I just don't see it.
I get what you're saying, SG. I totally understand, which means that we'll have to include somewhere within the legislation to allow for regulations to probably speak to these persons or something of that nature. I guess that's what it is.
Sorry, wouldn't it be under 7, look at 7I. Under 7I.
Which one? 1 or 2?
Sorry, 7.1I.
Right, but here now we talk, oh, sorry.
7.1I. Wouldn't that cover it? No? No?
No, it wouldn't. Not from my perspective. No, it wouldn't. Are you gonna?
No, sorry. I meant J, not I. J. Sorry.
Oh. No, but you see, no, it has to be a little more specific here if you're going to say that they're going to be registered or licensed, whatever the terminology is. If you're going to make them pay an administrative fee or not. All of those things, they have to be very specific about the powers, especially if you want to regulate them in this way.
So could we put another subsection in this, in under 7, to incorporate?
It could be there, or it could be in clause to just make it very clear in the rulemaking or in the regulations. I'm not sure where the drafter would prefer, but I think it has to be very clear that when you're talking about licensing persons, you are very clear who is going to be licensed and why and who they are. You need to know who they are, and the council should have the power to determine who they are and then have the power to do the licensing, charge fees, and so on. Because the council can only act based on what the statute tells it can do.
Chair, so based on what the SG is saying, because it now raises the question whether or not we want the legislation to cover paraprofessionals and, right? Because, I mean, why going to this tedious process of drafting regulations for grouping that we really don't want to cover? So maybe we can just remove them altogether. I mean, just exclude them and keep the exclusionary clause that we already have in the definition. If we aren't treating with them, if we aren't providing services to them, we just remove them. My thought. Because I think the term can be very broad.
We'd have to change G under 7.2. Right, so would we just take out the entire G?
Yes, just take it out. Yeah, but why? Why we need them? Maybe they can have their own body that covers them.
I agree with you. I agree with the member.
Legal team?
No. Paraprofessionals, they don't necessarily have to be teachers' aides, you know. Paraprofessional can be somebody applying a trade in a different area altogether and fall under something. So, yeah, maybe we just need to treat with them separately somewhere.
Let me speak with other educators on this, because these people are in the system.
Where are they defined in the system, in the Education Act? Where are they?
They're in schools.
No, I mean in regulation, legislatively. Where are they? Nowhere. So maybe when we're reviewing the Education Act, they be placed there, but for it to be placed in this legislation that really, and they're not covered anywhere else.
Why it is important to put them here, and that's why I say, let me speak to other educators on it. They support teaching. The paraprofessionals support teaching. It means that they contribute to the effectiveness of a teacher. And that is the importance of having them here. So let me have a wider discussion.
But Dr. Gordon, they're excluded. You're saying that they're under the definition of teach, it doesn't apply to them. Yeah, they're excluded.
They're excluded from the definition of teach. They're excluded from something, but it doesn't mean that they don't carry out a process. They're excluded from the definition of teach. They're not teachers. So, but they contribute to the performance of a teacher. Yes. So in that case, you don't want to have a bill that leaves them out completely.
So there's a situation where
they're excluded from the term teach and excluded from the profession teacher. They are not teachers, and they do not teach.
In 4, who the act applies to makes no reference to them. It makes reference to those who are teachers and instructors. So the bill does not apply to them in terms of the target of the bill. But they are just referenced in G. And that is why we ask, what are paraprofessionals? And if they are so defined.
But to add to that, but
They're
to
not
add to
in 4.
that as well, what I would probably want to find out is at 7.2G what services the council is contemplating on providing to these persons. Since they, right, what kind of services are to be provided, and then we can probably understand, you know, why they're here.
Because to be honest, if we go ahead and leave them at G, we're going to have to amend 4. Because 4 says who the act applies to, and they're not mentioned there.
Right.
So if we leave it there, if we leave 7.2G, we're going to have to amend 4. Yeah. So that's why I support what the member is saying. Let us make a recommendation from this committee that the definition of paraprofessionals, etc., is made when the Education Act is reviewed, and because nowhere else refers to this group in the education system in any legislation that I know of. I stand to be corrected. So take it out of this altogether because it's just here.
Let me ask this honorable group, please, to let me have a discussion with other educators and come back to you.
But with all of these questions that we have, the services to be provided, you know, all of those things, and then we can...
Because they are not, they're important to the profession. So let me have a discussion.
No doubt they're important to the profession. That's not what, we're not challenging that at all. We're just saying this would be the only piece of legislation that refers to them. They're not defined anywhere else. What is it that they're supposed to do, and how would the Teaching Council relate to them given Section 4?
Let us discuss it, and I come back to you. Thank you very much.
Minister, I know Dr. Gordon referenced other educators, but are there other jurisdictions that treats with paraprofessional, and how have they treated it? Because that may also be useful guide other than just speaking with other educators.
Thank you very much.
Okay, in terms of number 4, it says at clause 7E, it was proposed that a new subparagraph 4, Roman numeral 4, be inserted to read, any other person authorized by the council from time to time. It was a decision to be made as to whether 3, Roman numeral 3 as it is now, is wide enough. We decided that 3 was wide enough to capture any other instances that an authorization to teach would be necessary. And I think Member Green at the time also made that indication. I think Dr. Gordon had referred it to the Attorney General's chambers as well for them to provide us with guidance as to whether 3 is wide enough to capture all other instances where an authorization would be needed or any other. Right, we're of that view that it's wide enough. So I'm not sure if Madam SG wants to comment on that.
SG?
Thank you, Chair. It wasn't clear to me who is left out. So I guess the answer would be yes. And we're looking at 7.1E, just so it's clear, because remember there is also a 2. So 7.1E3. When you look at the chapeau of 7.1, the chapeau, we love using that word when we're dealing with bills. So the only time we get to use it. Sounds nice and fancy for the opening words of 7.1. When you look at the chapeau of 7.1 and then you look at the rest of the content in E3, it captures exactly what is being proposed as a number 4. So we think number 4 would be unnecessary. It also is not clear who else you're covering in this new 4. So we would suggest you don't do it.
I agree, Chair. That we don't need to add anything to it.
Okay. We don't need to add from time to time, is that what we're saying?
The law is ever speaking, Chair. So we don't need to say from time to time, it's ever speaking. It speaks there all the time.
So we will keep any other person authorized by the council?
So it's already covered under 7.1E3.
Second order?
I'm proposing that I agree with what Mrs. Gordon-Jones said. The proposal at number 4 is not necessary. You don't need to do any further adjustment to 7.1E. It could remain as is.
Okay. Members? Okay.
Fully agree, Chair. Fully agree.
Okay. We'll move on to item 5.
Five states, based on Dr. Gordon's redraft of Clause 24 below, the terms that need to be defined are formal educational setting and the non-formal educational setting, and the definitions were formal education, education that is institutionalized, intentional and planned through public organizations and recognized private bodies or settings, and non-formal education is defined as education that is institutionalized or intentional and planned by an education provider. And it further states that independent schools are part of the formal education system. So these definitions came into being because of, I think, the last sitting where Dr. Gordon had indicated that at clause 24.1, which says a person shall not practice as a teacher in an educational institution, and I think it was added, or any other formal or non-formal educational setting unless. So that's why the two terms were defined. So I'm not sure if the committee has any comments on that. Yes.
Okay. No, I think adding non-formal education just makes it way, way too wide, right? Because non-formal includes, let's say, the uniform groups and all of those. Go ahead, Dr. Gordon. Please explain. Because we had a little conversation.
Is an international term, and it's expected that you use it in your education programs because it's inclusive. Non-formal education goes beyond the schoolroom, and there are education settings in which we offer education. It's non-formal. It allows people in different contexts, children in different contexts, to participate. And so you'll find in any of UNESCO documents, when they refer to education, they refer to formal education and non-formal education, giving a feel of inclusivity. And in Jamaica, non-formal education is offered by some NGOs. It's offered in our lessons class.
The definition, okay, so just a quick Google search, because I agree with you that the thrust has been from UNICEF and from UNESCO that there needs to be a definition of non-formal education. So I completely agree with you.
It's organized, it's not...
Right, but the thing is, I'm not sure I agree with how we have defined it.
Let me hear what you...
So for example, just randomly on the internet, you see non-formal includes various structured learning situations which do not either have the level of curriculum, syllabus, accreditation, and certification associated with formal learning. So that immediately tells you what it is, while here, I am not sure. I immediately get it. I don't get it as defined here. Right. So I think we should revisit the wording of that definition, because the one that you find online immediately tells you what it is, while the one written here, I'd have to think to see what exactly is that. So read it again. The one online, non-formal includes various structured learning situations which do not either have the level of curriculum, syllabus, accreditation, and certification associated with formal education.
Right, so
Actually,
we're talking about the clubs and
Exactly.
those
Right.
sorts of situations.
So this definition I've read gives you a better idea, while this one doesn't tell me. Like, I literally don't know what it means from this. So the one here that we've been given today says non-formal education, education that is institutionalized or intentional and planned by an education provider. That's not clear enough. And I actually think it's actually not exactly what non-formal education is. So I would like to make the suggestion that we revisit that definition so that it is clearer what we're talking about.
It is international.
What you read, Chair, what you read seemed, yes, fits the informal. When I look at this, I might even want to add this to be recognized. The non-formal, as it is here, being education that is institutionalized or intentional and planned by an education provider. It seems even formal to me.
If you look online and see,
to being formal.
If you see UNESCO's definition,
but it's the same as one.
Exactly.
It's pretty much the same.
But it's a subset of the formal.
But it is not.
But Minister, I think if we look at UNESCO's definition is this written here, but it carry on to explain. So I think what we have done is taken the first sentence out of the UNESCO definition and haven't carried on, so it doesn't explain. So I'll read it here if you'll allow me. It says, UNESCO says non-formal education, that it is education that is institutionalized, intentional and planned by an education provider. The defining characteristic of non-formal education is that it is an addition, alternative, and or a complement to formal education within the process of the lifelong learning of individuals. So if we include the rest of the definition as per UNESCO, then it is clearer, but as is written here by itself, it's not clear enough. So I think we either have to just keep this and add the rest of the UNESCO, or... Right. So I think the rest.
But it is saying, and Dr. Gordon, you can correct me, it's saying that a person shall not practice as a teacher. Isn't that the paragraph? Isn't that the section that this comes in, 24? That's the section that this comes in, the formal and non-formal education, right? Right, Dr. Gordon? Mm-hmm.
It was the revision to 24. Can you read for us again what was the change to 24 that triggered this, please?
So for 24, the current clause reads, a person shall not practice as a teacher unless. So that's what it currently reads. So the change now includes in an educational institution or any other formal or non-formal educational setting.
But
I definitely think we need to expand on the definition and not just take that first line from UNESCO, because even the Council of Europe, their definition is non-formal education refers to planned, structured programs and processes of personal and social education for young people designed to improve a range of skills and competencies outside the formal education curriculum. So what it does, it helps the reader to understand what exactly it is, context, because this definition, I wouldn't know what it means.
I'm not sure that we need to go the route of expanding the definition. I'll tell you why, because it is a structured curriculum. It does not necessarily depart from the formal curriculum. It can, it does not necessarily depart. The non-formal setting is important for us because in Jamaica we have something called lessons classes. And it ought to be delivered by a trained person if it's organized and the children, you have their a setting in which the person is paying fees and all of that. It's education. Is structured, but is not in a school day. Whether or not...
Exactly.
includes extracurricular activities, debating clubs. Yes, by international standards, that's what non-formal, it includes, and which is why this is not enough. It's not just extra lessons.
Extracurricular activities are classified as extracurricular activities, and they can be sports, dance, music, whatever. It is not, the extracurricular activities are not structured as non-formal education. Let me put it this way. You'll find a wealth of definitions for non-formal education according to who and which group writes the definition. So in our setting, we have to decide what non-formal education is. We are fully aware of the lesson classes, and we want to capture those classes because they're structured and they should be delivered by trained personnel, which is why you capture it. So we could...
But sorry to cut you. It is by international standards, which we said earlier in our discussions, even today, we have to follow international standards. International standards define extracurricular as non-formal education. You can look at UNICEF, you can look at UNESCO, they do define, you can look at a lot of school gateway programs, they define it as such. It's not just extra lessons. It's learning by the definitions we read. It's learning outside of the formal education, for example, in team sports. So we can't work with...
Here, just for clarification, could you read the new provision, for the proposed provision for section 24, please? Yeah, because I'm trying to understand why we're here. Just read it for me again, please.
So the new provision reads, a person shall not practice as a teacher in an educational institution or any other formal or non-formal educational setting unless A, the person is a licensed teacher, or B, the person is an instructor. Should I continue?
Sports in Jamaica. Formal. Our core curriculum is not formal in Jamaica. It's not formal. Informal or formal.
So
our core curricular activities are really quite ad hoc sometimes, and you don't have to be a trained teacher to be part of those activities. So in Jamaica, we have never had that kind of structure.
Which is why maybe we need to relook that definition, that change, because when it says, because that was a red flag that I just raised and said to her, when you hear the full definition and then you say, the person needs to be a trained teacher or instructor. It's only the little instructor made me a little, can teach non-formal. That, the cultural context we have doesn't facilitate that. So rather than, as in the sense that a lot of our extracurricular teachers aren't trained teachers or trained instructors. So for example, let us imagine when I was at Wilmar's, they decided to put boxing as an extracurricular activity, right? I would participate, absolutely, yes. No, by definition, that's a non-formal education activity. Are we saying then that the person teaching the boxing would have to go become an instructor or a teacher, a licensed teacher? No, we don't want to put those hurdles in people's way. So I personally believe that section 4, that revised section 4, 24, needs a little revision because that's too much.
But I think based on what Doc is saying, they don't view extracurricular activities as non-formal education. This is a Jamaicanized version of non-formal education and extracurricular.
You started by saying it is an international thing.
Yes, but UNESCO is the only organization that sets international standards for education. The others don't.
No.
Actually,
Europe does. No.
OECD sets for Europe. It doesn't set for the world.
What I'm saying is, why would we put ourselves in a situation where we're only talking about extra lessons? Because if you think about what non-formal education is, you would be offending everybody at GC Foster College if you say today, if we as legislators say that sports, which is what forms most of the extracurricular activities, is not education, we would be setting ourselves up as policymakers because sports is recognized by UNICEF, everybody. Just last week, we had a senator in our State of the Nation talked about the importance of play. Sports is a part of our education, and it is a part of our non-formal education, not just extra lessons.
Or I call an SG.
Let us, please,
SG.
Minister, we have to, and we can, under UNESCO regulations, as a country, say for us, this is what non-formal education means. It takes the major, what I have put here, the major statement, and in Jamaica it does not include core curricular activities, because our core curricular activities are not structured as non-formal education requires. They're not structured like that. They're actually quite loose and quite agile and so on and so forth. Non-formal education is structured. It is always structured. And I can say it because I was the officer in charge at the time at UNESCO. It's all structured. It is very
SG,
structured.
can we hear you on this?
Thank you, Chair. Just to say from a legal perspective, and I'm just doing it from a pure interpretation perspective, the words that are in red are really not necessary, because what's in the bill now, a person shall not practice. It wouldn't matter whether it's formal or non-formal. It's a prohibition, a general prohibition. So from just an interpretation perspective, you're not losing anything if you exclude the words in red. I would also just like to make a comment on 24.2a. The Chambers cannot support the concept of something called an admonishment. Clause 59, I believe, that deals with disciplinary sanctions, does not use that term. To be honest, I don't know of that term being used in legislation. I wouldn't even know how to begin to explain it or define it. And if someone was quote unquote admonished, not sure what that means, and I'm sure it would be challenged. We don't support the use of this.
SG, we're not hearing you clearly. And so I missed what you said about the use of the word admonish. Where is that word?
24.2a in red. In the document that was prepared. A person who contravenes, so okay. It says a person who contravenes is subject to a admonishment by the council. I don't know what that means. And I'm saying from a legislative perspective, in law, we don't use that term. Further, clause 59 of the bill, when it deals with the disciplinary sanctions, does not speak of admonishment. It speaks of warnings, censures, so on. I'm saying if you leave this in, it could be the subject of challenge. You may have a problem trying to enforce it. It's not clear what is meant. So we don't support this terminology.
Chair, through you.
Reach there yet, so I didn't notice it. Absolutely
yes,
not.
Yes, we were not there as yet, but this is something that was suggested by CPC when we were having it. I think it was LRD. It was. I think it was Mrs. Wilkins at the time when we were having the technical discussion.
We would have to use a term like from 59.1b, where we say censure or reprimand the person.
Right. However,
but
there was another.
And that would be supported, that
term.
Senator would be supported by us in the
Sorry?
chamber.
You mean my suggestion of using censure?
Would support your suggestion, Senator.
Okay, thank you.
The terminology from clause 59, or just referencing clause 59 to say you'll be subject to a disciplinary sanction.
If we look at, if through you, Chair, if we look on page 4 of the responses, when you would see a different proposal that was made in terms of clause 24.2, but because we're not there as yet, I'm not sure if I should wait or we should treat with the tiered approach that the Chief Parliament, the Office of the Parliamentary Council made in relation to the tiered approach that the committee had suggested.
All right. Could we settle on this issue of formal and non-formal first before we go there?
Madam Chair, if based on all the conversations we've had around 5 with formal and non-formal education, I would like to posit that we revisit the new phrasing of 24(1) because of the fact that I'm also suggesting that non-formal education must include extracurricular activities. And as such, if that is accepted, that non-formal education, as per definitions globally, includes extracurricular activities, then we would have a problem asking in 1 for non-formal education to be carried out by instructors or trained teachers. It would be too much. And I don't think that we alone, while everybody knows that I'm one of those persons who believe we should Jamaicanize a lot of things, this is not one that I'm suggesting that we do, because education and such sectors exist within a global context, and it may affect treaties down the road, etc., and then we have to come back to Parliament to change these things. Once UNESCO, etc., and other entities have looked at it, and I use the example of Europe, their Council on Education in Europe also defines non-formal education to include extracurricular activities. I don't see how we would lock it out, and it would actually be offensive to our sports college here in Jamaica for them not to see what they do primarily as part of the education system. So I really and truly think we need to change that idea, that definition in 24(1), that suggested definition. And secondly, the definition of non-formal education here needs to be expanded to include extracurricular activities.
Chair, may I?
Go ahead, Dr.
Considering the structure and delivery of education in Jamaica, we cannot, as a country, include the extracurricular activities as part of our non-formal definition. It is our extracurricular activities are not that structured. We cannot include it. And I can take it one step further. I can write to the person who is now in charge of that part of education in UNESCO and get clarification, because countries are allowed within their cultural context to modify and adjust some, not all, but some of the global definitions to meet their own needs. And in Jamaica, extracurricular activities right across our system, from primary right up to secondary, they are not structured and cannot be considered in a non-formal setting.
I am with Dr. Gordon on this one.
But then we couldn't use this definition you have here, because this definition you have here is taken from the first sentence of the definition by UNESCO, who then continues by explaining what it means. And it does include extracurricular. So we can't, if I'm not agreeing with you, absolutely not, I'm not.
What UNESCO has written includes extracurricular activities.
But what I'm saying here, remember when I read it, I need to find it back for you.
Yes.
This is the first sentence from a definition that exists. If we're going to if you're suggesting that we take a definition from an entity, we have to take the full thing. We can't just take the first sentence of what they have defined.
All right. So we can go on to talk about the curriculum as it has been given, but UNESCO does not speak of extracurricular activities.
It does. If you read the section, it says, no, I'm looking at the wrong one. Let me find it back. But it goes on to explain what is. So, for example, UNESCO, within the process of the lifelong learning of individuals, and by G.C. Foster, I'm going back to G.C. Foster, they consider themselves a part of the education system, the lifelong learning of Jamaicans. So are we saying no to that at this point?
No, I agree with that, but G.C. Foster offers formal education. You have trained education.
Exactly, sports.
But
sports is the primary part of our extracurricular activities.
The people who teach, the graduates of G.C. Foster College, who are in education, they are trained teachers.
Exactly, but what I'm saying is a lot of I'm talking about the area of sports.
We're talking about extracurricular activity, because
Hold on.
sports, you have sports in
The
curriculum.
large majority of extracurricular activities in Jamaica are sports activities. Am I correct?
Yes.
And sports is treated in our education system through the GC Foster as a part of the learning for our children.
But sports in the curriculum.
Right, so what I'm saying is then how are we then saying non-formal education is only extra lessons? It doesn't add up. It has to include, so are we saying then that debating club, are we saying that the chess club is not a part of non-formal education? I completely disagree. I would have to be shown where it's not.
Okay,
I suppose we
Charlene,
need to
can you
move on.
shed some light on this?
Thank you, Madam Chair. Just to reiterate what the SG was saying earlier, which I thought about, that it may be not necessary to include the terms. Perhaps why they came up and why an attempt was made to modify the provision by the insertion of the terms, perhaps that was because of the discussion on practice as a teacher, to perhaps explain what that means. And now that we have settled that issue, well, at least partially settled the issue about practice as a teacher, it doesn't, it may not be necessary, or it's not necessary to use the terms educational, formal educational setting or non-formal educational setting, and the provision should remain as is, 24(1 that is, should remain, the top part of it, the chapeau or the opening words should remain and just say a person shall not practice as a teacher. But moving on from there, the subclause 2 of 24, an attempt was made to modify that because of the issue of whether, if somebody is practicing without a license, if that person should be subject to a criminal sanction. And therefore, the ministry was attempting to say, first, the person will be subject to disciplinary action by the council, and failing which, then the criminal sanction would follow. If the person has been warned or so on, and then the person does not act to get their license, then certain other, the criminal penalties would then follow thereafter.
And I agree with the idea behind it. I just think I agree with the SG that the word admonishment should not be used. We can take the same words from 59B, which are censure or reprimand, just not the use of the word admonishment, I think is the main thing. I mean, as a teacher, teachers love to talk about admonishing with regards to behavior, but I think legally we should go with what's in 59(1)B, which is censure or reprimand.
Chair, I have my own comment on that. When you are insinuating discipline, you should be clear with the terms that you're using. When you use big terms as admonishment, which the synonyms are clear, I mean strong warnings, formal warnings, that is clear to everyone. And you should offer those terms that are clear and precise in nature, so that people don't leave with no other opinion as to what they may be. And I agree that in terms of what is contained in 59, those are terms that are very clear in administering discipline.
All right, so members, terms of clause 24(1), or clause 24, let's just say, will remain as is.
So, Minister, we're saying we won't include the formal or informal part of the definitions, and that way we won't have to define them. Okay.
Is there further discussion that should be captured?
And I think it happened because of the discussion around the tiered approach. Yes, so that's why the idea.
Madam Chair, if I may.
Please go ahead, member.
No, Dawn Charland here,
okay,
Minister.
Sorry. Okay.
So therefore, 5 is connected to 6 on the sheet that was submitted. So the committee needs now to determine whether they will accept 6 or, well, I would imagine that they would not, because in the first offense, you wouldn't have that it would, this in essence is a criminal offense. In the case of a first offense, to a fine not exceeding $200,000. So that could be deleted, and instead the one previous where we spoke to censorship and reprimand. So in essence, that would be 24(1). And then a determination could be made as to what comes next. After the person is subject to censor or reprimand, what is the next step? And perhaps what Dr. Gordon had suggested could be taken on board, which is the first draft, where if the person does not get licensed within 45 days, then they would be subject to the criminal sanction.
So that's page 4 in this. No, this one.
The top of page 4.
No, it's down the bottom is where it outlines at the bottom. So that's what you're saying.
Yes.
But just to indicate, if I may, Chair, just to indicate that if you look on page 4, there is also another suggestion in terms of the 24(2), instead of using censorship, just to take from the word that my friend used just now. It was taken from the Legal Profession Act, where it says, I'm at page 4, where you would see 24 on that page as well. It says, where the council, and I'm reading clause 24(2), says, where the council is satisfied that a person is practicing in contravention of subsection 1, the council shall, in writing, direct the person to make an application for the license or authorization to teach, as the case may be, within 45 days of receipt of the notification of the contravention. And then it further reads to say that a person who does not comply with the direction within the specified time under subsection 2 commits an offense and is liable on summary conviction in a parish court to a fine not exceeding $300,000. So that is what, when I looked at the Legal Profession Act, I was saying that we could adopt this writing instead of the matter of censorship.
It gets my vote. So it takes out the issue of the admonishment and all of that, and it takes out, I like, except with the use of the formal or non-formal education. I would take out that sentence as we agreed before. That's phrase, but I like the concept behind the suggestion at the bottom of page 4, as is.
Let me understand this now. In the first instance, there's a warning that you have within 45 days to go get your act together. But you still continue to teach. Failure up to the 45 days, then there's another warning that would suggest that you are now liable on summary conviction in the parish court to be a fine of not exceeding $300,000. But that's another warning now, you know.
No. That's not a warning anymore.
No, the person who does not comply. Yeah. So, no, and that's what I'm trying to capture in my mind. How is that triggered? The 45 days would have expired.
And no license or registration.
And the person would not have complied.
Yeah.
I want to ensure that the person stop teaching.
Right, and that's my question. During that 45-day period of time, can the person continue teaching for that 45 days?
Yes. Yes.
Okay, so yes.
It is understood.
But on day 46, they can't turn up.
Right.
Okay. So where? So how we treat with that?
No. So if day 46 comes and they turn up, then section 3 now is triggered. Right.
My only concern with that is that, you know, there's a time frame that is going to be treated with that part of it. You go court or what? Do you still continue to teach?
No, but you can't. You wouldn't be able to.
So how? Where? That is after the fact.
Members, please remember to turn on your microphone.
Oh, I'm sorry. I'm just saying that it says on summary conviction, which means you have to go to court, which could take at day 46. If you turn up at school, we should make it be a situation where they have to go home and start the court process, not that they stay in the classroom during the court process.
But does that have to be explicitly stated in the legislation?
Yes, it's teaching.
No, but you see, there's a process now. You have to go through the court proceedings to get the summary conviction. And we know how our court system stay, how long that may take. The person is still teaching.
Or we put it on the principle to ensure that the person is actually...
It has to be somewhere that if you don't comply, look, if you don't comply, if you stop teach. It can't be that you continue.
Why do we need the 45 days? Your
Well, no, forget 45 days. It could have been 10 days, Chairman. It could have been. This is just migrating a principle or a provision from another legislation using 45 days. So we can change it. My concern is that you are provided a notice of a defined period in which there is an expectation that you comply, and you have all the necessary provisions available to you to comply. If you have failed to comply with this 45 days that is given, and you don't comply, why you should be continue teaching?
I support what you're saying, Senator Gale, and I believe at the end of the 45 days, something in there should state you should cease practicing as a teacher or an instructor while you go through the process in the parish court.
SG, can you come in, please?
Thank you. Except the process in the parish court is not automatic. It means that a claim would have to be filed. The process itself would have to be triggered. Just because the law says you're subject to prosecution in court doesn't mean it just automatically happens.
So we're saying, SG, we need it to be specifically.
Right. So I just wanted to just say that. So because there's no automatic triggering, you may have an even extra delay. The way in which matters like this are addressed in other pieces of legislation, and we're looking at enforcement, is for, well, in this case, it would be the council to issue a suspension letter, a suspension notice. So the teacher would get something on day 46 to say your registration, for instance, is suspended.
But remember, they don't have any license, so what are you suspending? Remember, they don't have any license. That's what caused this issue. So there's nothing for the council to suspend because they don't have a license.
No. the suspension here must be a suspension from continuation of the performance of duty.
Yes.
Not, you're not on a license. That's separate. What I want
I'm responding
to
to
ensure.
what the SG said. I'm just
and
pointing out to her that there's nothing, no license to suspend.
Thank you. I noted. I note the error I made. But the concept is something would have to be issued to direct whether the head of the institution, as well as perhaps the same teacher. So the teacher could perhaps be served with court documents, but perhaps the head of the institution could be served with something to indicate that the teacher is not registered and should not be allowed to practice teaching in the institution. That could be a suggestion that you could consider.
Look, my concern is the fact that in the first instance, you're in breach and you have 45 days in which to fix that breach. Now, after 45 days and it's not fixed, you are now flagrantly in breach, further in breach, and so there has to be a cease.
But my question, though, Madam Chair, is why do we need the council or the principal or anybody or the ministry to issue a warning or whatever it is? Why can't the legislation be reworded so that it is very clear? Because what happens if for some reason the council forget to send a letter? We're talking about enforcement here, which has been a problem with a lot of laws in Jamaica, and we're making the teaching profession safe for our children. So you can't just disregard the rules, okay? Or you're a part of the problem. So what I'm saying is, can we reword the legislation, Mrs. Gordon-Jones, to state clearly what happens after the 45 days? Can we do that?
Yeah,
no, that's what I'm asking her to just, is it even possible to say immediately on day 46, and I'm giving you layman terms now, on day 46, the teacher is not to be in the classroom, and we make it a responsibility of the principal to ensure that that is enforced. Is that possible? Is that a feasible thing to do in the legislation? Well, because if we're to make it where it's up to the council to then write a letter to the principal who then informs the teacher, to me, that process is too tedious and it doesn't go directly to enforcement.
All right, Ms. Jones, what do you think about that? I think Member Brown?
Yeah.
Or is it on the same matter?
Yeah, on this matter, I'm deeply concerned that legislators want to become judge and jurors. The reality is that at this point, it's an allegation. The teacher may be challenging the allegation.
It's not an allegation. Your license is either up to date or not. It's not an allegation.
I listen to you. I hope you're going to pay me that courtesy of listening to me. It's an allegation. Somebody said you have no license.
Member Brown, the council would know. The council keeps track of the dates.
It's still an allegation from the council. There may be a defense provided for the person. I don't know. But it can't be for us to be trying to try the matter here at this level in the legislation. It is going to go to the court. Let the court decide it.
Chair.
And so I am not, if the principal wishes to suspend, place an interdiction, or whatever method, or terminate, those are, of course, open to the employer, because this is an employee too. So I would be very careful of trying to judge the issue and the mere allegation. And so
Chair,
it says,
Chair, it says here in 24.2, where the council is satisfied that a person is practicing in convention of subsection 1, the council shall in writing direct the person to make an application. Now at that point in time, that individual can say, whether or not they have a license.
Exactly.
Because the council would have been satisfied that they are practicing with a C without the license. That gives the individual the opportunity to say, you're wrong, I have my license. Now, it is the contention that I would have raised is that after the 45 days, you get your chance to go do what you need to do and get your license. If you fail within the 45 days, then there should be another trigger that you ought not to continue to practice in the classroom. It can't be an allegation anymore. The council would have been satisfied, and give evidence of such.
So, Madam Chair, can we go back to the answer?
What happens after the 45 days? Is it?
But Mrs. Gordon-Jones hadn't gotten a chance, Minister, to respond to what I had suggested. Is it possible, Mrs. Gordon-Jones? Or to Mrs. Douglas Sherland, is it possible for us to put something in the legislation? I mean, not right now. I mean, if you could spend some time and look at how we could put something here, is it possible that that could be considered and be brought back to us?
But perhaps if we say a person who does not comply with the direction within the time specified shall cease to practice as a teacher, I don't know if that is sufficient. Shall forthwith, but what would compel the person to stop?
So the burden would now be placed on that individual because it's in the legislation. What comes after now would be the triggering of the court proceedings. So at least the person knows that after 45 days you should not be in the classroom. And I think the knowledge is what is important. So once it's there, they can't say, oh, they didn't know they shouldn't be in the classroom anymore.
So the court would now take into consideration the teacher's failure to, one, cease practicing, yes, and also not to have conducted themselves in terms of getting the license.
Yes. But I think we're forgetting also a very important thing. Quite often principals say, but it's going to have a shortage. We have to put something where the principal is required to ensure that the person is not in the classroom. Right. It is important that there is some responsibility on the principal that they don't have because the teacher could say, but the principal didn't send me home. And the principal could say, there's nothing in the legislation that requires me to tell you not to be here.
But the mere fact that the legislation would speak to that person ceasing, it doesn't really matter what a principal says. You can't defend yourself to say that a principal has not sent you home. The legislation is clear.
Theoretically. Does it hurt us, though, to just put some responsibility on the principal as well? Not a fine, not a punishment, but just ensuring that the principal triggers it. Sorry?
Through notification.
Through notification.
Right.
Yes.
Excuse me, though, Chair. There's an absence of natural justice principles. I didn't hear that coming out. So I had suggested that the head of the institution could have been involved. But when that happens, it means that there must be natural justice principles that will apply. And I've not heard that in the discussion. And that's a requirement under the law.
To cease teaching?
Because everybody is still presumed innocent until proven guilty. Just
you
because
you don't have the license.
Offense. Yes, so why are you taking me out of the classroom? What would you do? Is it that you're going to issue me a notice? Those are the things that you would need to put in legislation. You can't just, the legislation would have to be clear. So it's not just
that's what we're saying. That's what we're asking for. We're asking for the legislation to be clear on all the steps, and that was my question to Mrs. Gordon-Jones. Can we rewrite this section in the legislation so that every step is clear, who has responsibility and what happens next? And that was the question I asked, and I'm I suggested that time be taken to redraft the section to facilitate that process.
But additionally, Chair, I mean, as an attorney, I cannot practice without a certificate. I can't drive without a license. There is no natural justice where that is concerned. It's either I have it or I don't have it.
Yes, but if you are caught, what you're doing, what happens is you're issued with a ticket. Does that prevent you from driving the next day or continuing? Unless you're locked up.
But that's where the court proceedings comes in. So the person,
Sorry, member, the issue was what happens during the interim of the court proceedings. Before court, you remember that court proceedings may not be instituted immediately, you know.
SG, I understand your point. And we're just asking then, because your point is valid, can we get the section rewritten based on what we have discussed here today? We want a trigger point for each step. At the end of the 45 days, what happens? And who is responsible for issuing notices? That's my suggestion, Madam Chair. Because the SG is correct. When you're a driver's license, you get a ticket. It doesn't stop you from driving. What we want is a person to be out the classroom.
And through you, Chair, if I may, the other aspect of it that I was thinking is a matter of the person's salary during that time.
There's a way to treat with that.
I think the suspension.
There's a way to treat with.
1 second, Member Gale. You want to finish?
Thank you, Chair. So in terms of I think maybe you can suspend the person from the classroom without salary. I mean, you'd have to consider the whole matter of having a sit down to indicate that this is happening. So the employer would have to do that. Say this, we have no take from the council that you no longer have a license to practice, and so you would have to be suspended from teaching until such time or till the matter is heard. But we would have to consider that aspect of it, because the teacher would have been paid during the time, and the fact that he or she's now taken from the classroom, then the matter of salary would be an issue as well.
Member Gale, Member Rodriguez, Member Gale is ahead of you.
There's a way to treat with that. In that, first of all, you want to create this deterrent from not having teachers getting this 45 days and that they continue to behave as if it's business as usual, right? So, Solgen spoke about natural justice. And in the first instance, what could take place is an administrative type of suspension that takes the individual away from the classroom. We can determine, and the council can determine if it is with pay. You have in some instances where they get 3/4 pay or things like that in the public service. But you really don't want the individual to be perpetuating this type of behavior. And so you have to create a deterrent. Whether that deterrent goes through a process now of the person appearing before some panel where the person can explain themselves, that's fine. I am not disputing when that can take place, you know. Solgen spoke about a process. So you're creating the process, but you can't have the person appearing undetected and continue to teach. So we have to have some fix where that is concerned.
Madam Chair,
Dr. Gordon.
so
1 second, Member Brown.
Sorry.
Dr. Gordon had her hand up.
Yeah.
Thank you, Madam Chair. I just want to ask a question of SG. When a person has been given 45 days to apply for a license, and within the period of 45 days, that person does not apply for the license, how do we explain natural justice in that context? I do not understand it. Thank you.
Natural justice applies in every context. Perhaps you want to shorten the time. Maybe the 45 days is too long. Maybe you want to start another process during the 45 days because the 45 days is triggering a criminal process. Perhaps you want to start another process prior to the 45 days. But natural justice is always going to apply, whether you have it as 90 days or 180 days. There are models, where you can also issue a notice and immediate suspension, but still give the person opportunity to be heard. And you would have to fast track that as well.
So I would add, Dr. Gordon, that a notice be sent prior to the expiration to say your license is going to expire, right? In 30 days or whatever the period is. Right, just an alert to say that your license is coming up for renewal, right?
Can we just use birthdays as the days for that so that everybody knows your license is expired on your birthday, just like your driver's license? Because that way it eliminates the need to send out those reminders. If we just use people's birthdays, and you know that your license is up on your birthday.
Through you, Chair, if I may, but this situation, it does not really apply to a renewal process only. It can be a new person coming in without a license or not authorization to teach. So therefore, in that case, you wouldn't have the council wouldn't be able to send any notification that the license is about to expire.
That's for those who are in. Okay. Member Gale?
I have my own views in terms of the person coming in without a license. Should not be able to come in without a license. And that is where, in another area, we spoke about the employer's responsibility to ensure that that person don't come in and practice. No doctor can go practice on ward without a license.
But in that case, Member Gale, based on the fact that the government is a major employer, in order to pay that new person coming in, you have to have the council confirm, right, that a license was issued. And if they're not issued a license, there's, yeah.
We agree that we'll just get a draft from the legal team as to what could possibly be the wording. As SG says, it exists elsewhere as well as, you could look at other legislation and we see. Yes, so we agree. Thank you.
I want to thank Chairman Campbell for pausing to recognize the rights of individuals, whether they have a license or other license which I failed to renew, and allow for a different formulation of the thing. As the SG has said, there's approach to punishment and discipline that exists in the public sector here in Jamaica, and there's nothing wrong in copying that and looking to see how it fits into this situation. So I'm at ease that we're prepared to look at it differently. And Senator Gill, the question of rights of workers is something that I know you champion very well. And mere allegations can be disproven.
Member Brown, thank you for your intervention, but I don't think it's an allegation. If you don't have a license, there's a council that takes care of the licensing process, and they would know whether or not you have applied for your license. So I don't think it's an allegation. The council.
Why do we take them to court then if it's more than an allegation? You see, allegation is used broadly here, Minister. They allege that something is without a license or she is without a license. It's an allegation. You may feel that you can prove your allegation, but it still remains an allegation. And so it is for those reasons why the due process need to be inserted in whatever we're doing. I'm not supporting somebody going without and teaching without a license, but I'm conscious that an allegation is an allegation until proven otherwise. Our jurisprudence says you're innocent until proven guilty.
Let me deal with, again, that particular clause where the council is satisfied that a person is practicing in contravention of subsection 1. The council shall in writing direct the person to make an application for the license or authorized to teach, as the case may be within 45 days of the receipt of the notification. Now, the person also have the opportunity, if the person is satisfied that they have a license, to be able to respond. Yeah? If I have my license, I can respond and say to council, you're wrong. I have my license. That is responding to the allegation. I don't know if we can have a situation where we insert that opportunity for the person to respond accordingly within the 45 days. To say it explicitly.
But somebody wouldn't have an allegation against them.
I don't know.
Because they know that the next step is no, come out to the classroom. Exactly.
Well, for the abundance of doubt.
You mean to respond to Senator Brown?
No, I'm not responding to Senator Brown. I'm responding to where there's maybe a view.
Where there's a vacuum?
There's an allegation that you had the opportunity to respond. Within this 45 days, we can do everything possible to clear it up before we get to post 45 days. The challenge, that I have is that you have persons who are going to conform and are required to conform, as opposed to those who are not conforming and insist against conforming. So I want to close that gap.
Madam Chair, do we talk about rights without...
Go ahead. Do you have your hand up, Dr. Gordon? Go ahead.
Do we talk about rights without responsibility? If you are a teacher, you have a right and you have a responsibility as a professional. And if the requirement of the profession is that you ought to be licensed, registered and licensed, then I cannot see any reason why a teacher cannot comply with the application for a license. Within the period, we may adjust the periods as SG suggests, so we say maybe 20 days and the council will inform you, and then for another 25 days. We may make those adjustments. But after that, if the person refuses to get a license to practice, then the person should not be in the classroom at all. It's finished. That's it.
Go ahead, Member Hamilton. Sorry.
Doc,
yeah, go ahead.
The Legal Profession Act. Am I permitted to just read what they have in their legislation, and then maybe we can tailor?
Yes, Member.
So at 3A it says, where the council is satisfied that a person is practicing in contravention of subsection 2, the council shall in writing direct the person, A, where the prescribed fee has not been paid, to pay the prescribed fee within a specified time. B, where the council is not satisfied that the prescribed requirements for continuing legal professional development have not been met, to provide within a specified time evidence of having met the prescribed requirements. Or C, where the council is satisfied that the person is unable to supply evidence of having met the prescribed requirements, to attend and complete within a specified time specified courses of training in order to meet the prescribed requirements. 3B, a person who, having been issued with directions under subsection 3A, does not comply with the directions within the time specified under the relevant subsections, as the case may be, and B, continues to practice as a lawyer, is guilty of professional misconduct. It means that the opportunity has been given for the person to comply, respond, and to prove that they have met the requirements to continue practicing. I don't know if we want to probably use this or tailor it in such a way for the teaching profession, something similar.
Member Hamilton, what happens after that? When you go
it says in respect of each calendar year, the attorney shall before whatever the 31st of January complete and file with the consular declaration. So it goes on to say other things.
But is the lawyer practicing that during that time?
It does not state. It doesn't state.
Madam Chair, I think one of the things we have to remember is that teachers are integral to the development of the young, the most vulnerable group in a society. And as such, we have to be very clear what happens with these teachers if they do not meet what is necessary. And as such, we can't leave it as open as it is for the practice of law. We have to be very, very specific, and we're recommending that if after the 45 days is long. During that 45 days, I agree, you should indicate that they have an opportunity to come forward and indicate if this is incorrect, etc. So that first part is correct from what I agree. Right, so that takes care of the natural justice issue. So they come forward and say, but I do have it, your system has made an error. Yes, so we allow for that. But if after 45 days, it needs to be clear that you have to be removed from you should remove yourself from the classroom, and this process is triggered where it goes to the parish court. I'm just suggesting if that can be drafted so we can see.
Chair, Martin Albrecht.
Yeah.
Yes, we can take all of this on board. The chambers can work with the ministry and come up with something. I think we already have enough guidance, not just in other laws, but also we've listened to what the members have said. So I am proposing that the technical team can be tasked with trying to give you maybe one or two options, and you could move on.
All right, thank you, SG. Go ahead, Ms. Sherlin, on the next, number 7. 12:30. Number 7? Is number 6? 6? Sorry. On page 5. All right. Ms. Sherlin or Ms. Gordon, you want to continue? I think there was another part to the question, yeah. On page 5.
Also in relation to the proposal to penalize the employer under clause 24 for employing a person who is not registered and licensed, Member Brown asks who the employer who would be liable under clause 24. Would it be the board, the chairman, or the individuals of the board? Also, should the board be indemnified if they act in good faith? Our response is, after further examination of the matter, we are not of the view that an employer is to be penalized for employing a person who is not registered, licensed, or has an authorization to teach, as a license is personal. That was the response. I'm not sure the committee's response to that.
What this is doing is that it absolves the employer, the board, from a responsibility and place the burden on the teacher. And so all areas in terms of licensing and registration rest entirely up to the teacher. I understand where the government now being, the state being the employer, is absolved and all other associates responsibility. So the burden is being placed on the teacher, go get your license.
But how is it
Member
that,
Hamilton?
I'm just thinking it through because that hurdle to be qualified in the first place, if I am going to employ a teacher, how do I just ignore the fact that somebody has no license? It's a bit difficult to absorb.
Very subjective, you know.
Yeah.
That's a subjective feeling you're having, and it's not extended to everybody. So we have to ensure that the rules are objective versus subjective. And as such, it's not enough that someone should know not to employ somebody without a license. We have to put it in there that and I'm not talking about the state now, because that's not something in real terms that the state itself alone can take on. That's not feasible. But the manager, so it's not necessarily the responsibility of the employer, which is the state, it's the responsibility of the manager, which is the board or the principal.
It's not the manager, but it's the board is involved with.
Right. So I think we can do it as such, Madam Chair, that it is the responsibility of not the employer, but of the board or the principal. But it can't just be left to the discretion of.
Go ahead, Dr. Gordon.
We should keep in mind that the list of licensed teachers will be in the Gazette. It will be gazetted and updated annually. And also online, people will have access, persons will have access to the information, whether or not a teacher is licensed. So it is.
It's a loophole that is created, you know.
Pardon?
I think a loophole is created when it is done this way. Because even though it is there, it may be published online somewhere, what we're saying is that whoever is employing the teacher does not have the responsibility to ensure that the person is licensed. That's how I see it, and can be ignored.
Most teachers are employed by the board, but the board represents the government. So the question came up as to whom will you direct this responsibility? The board is a volunteer body.
What's wrong with using the principal since it's an employed body?
The board.
What is the board is volunteer?
Anastasia, you can guide me, please, in terms of the Education Act. The board has certain responsibilities, hiring, firing, right? Ms. Gordon?
Yes, Chair. So the board employs, and as Dr. G indicated, the board currently is a voluntary body. So,
what is stopping us from making it the principal's responsibility? That's what I'm not understanding. Is there some law to prevent
hold on a second. The board is going through this, right? There's a requirement for you to have a resume. There's a requirement for you to have graduated from Teachers College. You have to come with some certification that you've graduated from Teachers College. This is just another requirement. Why can't it be? And if you don't have a license, sorry, the process ends here.
But Chair, even the explanation just now saying the board is voluntary, it does not absolve them of having the responsibility of ensuring that we... Right, well, don't volunteer, because, you know, you can respectfully decline any proposal for you to be on a board.
but as Chair said earlier, whenever you're being employed as a teacher, there are documents that you have to submit, your TRN, your NIS, your birth certificate, your qualifications. So the license would just be an added document that you would need to submit.
Absolutely, and if you don't have it, that's the end of the process. All right, so members, I think we'll wait on the rewrite.
The response
we'll
here,
wait on the rewrite,
the response here, is that the employer is not to be penalized for employing the person. That's the response. But it don't stop the employer from being a gatekeeper to ensure that as part of the qualifications to enter to practice, you must have to continue, that you must have your license. Don't leave it that vague in our mind that, yeah, you can come in and there's no responsibility. It's just that you're not going to penalize the employer. And that was a concern that Member Brown would have raised, whether they're going to penalize the employer or the board or what. So we understand that. But they are still a gatekeeper. And they must still perform the functions of being a gatekeeper, not to ensure that people walk through the system without the license.
Put this in the regulation, set it out in the regulation. As Minister said, the required documents for employment as a teacher.
If we could just complete this page number 7, 7, 8, and 9. We can 7, 8, 9, 10, 11. Can we complete those? And then we will come to an end.
In continuing, it says, note further that in relation to clauses 25 and 26, and the reference to the Nigerian Act by the Teachers' Colleges of Jamaica, there are provisions which treat with criminal penalties for pretense, fraud, and misrepresentation under the Nigerian Act. So the submission from the Teachers' Colleges of Jamaica, where they propose the matter of giving direction to reprimand a person in offenses of fraud and pretense, it would not have been a proper comparison, because the Nigerian Act, it does provide for pretense and fraud and misrepresentation.
True, Chair, that would be in relation to 25, section 25, but for 24, where there was an intent to criminalize, I believe the Nigerian thing that's where they're pointing us to Nigeria, that there are other ways to deal with it other than criminalizing the teacher.
Yes, remember, they did it for 24, 25, and the 26. They made reference to it in all of the sections regarding offenses.
Could we see what those clauses look like in the reference to the Nigerian Act?
So remember, Gail, you want it to be sent to the committee, or you want me to read the provision? Okay, so section 17 of the Nigerian Act, it says, if any person, for the purpose of procuring the registration of any name, qualification, or other matter, makes a statement which he believed to be false in material particular, or B, recklessly makes a statement which is false in a material particular, he shall be guilty of an offense. 2 says, if on or after the commencement of this act, any person being a registered member of the profession practices as a registered member of the profession, or in expectation of reward, or takes or uses any name, title, addition, or description, implying that he is in practice of a registered member of the profession, he shall be guilty of an offense. And it also has a proviso that says, provided that in the case of a person falling within section 10, and it it goes on to some other provisions in the Act itself. But it does provide for an offense being committed if you pretend or fraudulent.
Similar to what we are seeking to apply here.
Right.
So it's just a confirmation.
Right. And
even
to
though they have
clarify
spelled
as
it out a little differently, more detailed.
Yes.
Can those relevant sections be scanned and sent to the committee members?
No problem, member. We can do that.
Or carry on.
Number 7, it says Member Brown also asks whether short-term licenses should be granted and same be provided for in the bill. And our response is there will be no short-term licenses. However, authorization to teach will be available until the person is able to fulfill the requirements for licensing.
Madam Chair, can I ask a question of the team, please, through you? This has just triggered something in my mind. After that 45 days that we spoke about earlier, where the person is asked to leave the classroom, it needs to be clear that after that 45 days, the person can't get authorization to teach. It has to be they go and get their license. I just want us to be very clear, because there was a loophole there that I'm just realizing where the person could get authorization to teach because they don't want to go and renew their license, because renewal of the license requires that police record. So just to protect the young ones, where I'm just suggesting that we ensure that it is clear that if you choose not to renew your license, you should not be allowed to go and get an authorization to teach. Dr. Gordon, I'm not sure if...
Why not? Why not?
Because remember, what we're trying to do is to know what we're trying to do, Minister, is to ensure that people follow the rules to practice in our classroom. No, she don't want.
Look,
then you apply specifically, Minister. If someone,
right,
if someone says, right, if someone decides that they only want to fit under Section 43, which is that they only have, and Mrs. Gordon-Jones, I would seek some advice from you here. If someone decides that they don't want to have a teacher's license, a license to teach, what they want is only authorization to teach. Let us say for some reason somebody decides that's what they want. In that instance, they need to, I am suggesting that they write a letter indicating that they have no intention of applying for a license and would just prefer to operate as somebody authorized to teach. Because what you don't want is to leave it open. But I'm not even sure if that's allowed.
Here is my concern with that. This authorization to teach has to have a time frame to it.
Yes, definitely.
And I can see a cadre of persons who might seek the access of authorization to teach being, let's say, some retirees, persons who would have retired, and you may have a situation where, like the migration of teachers, and you need to fill a gap for a time frame. So those persons who don't have a license, no longer have a license, but you want them to teach, they can fill that gap by applying for the authorization to teach that is applicable for a determined time frame.
But remember, authorization to teach also has a time frame. As per Section 44, it says under 44.3, The period specified in the authorization to teach shall not be longer than 2 years from the day the council grants the authorization to teach. So it's not, and may be renewed, but we should put that it can't be renewed if you had written to say you had no interest in a license. Because it cannot be that you come through the back door, for want of a better word, of into perpetuity, you never get a license, you just keep renewing your authorization. Which is why we go back to the point, if your license has expired and you have reached the 45 days, you do not qualify for an authorization unless it is you're saying you have no intention of ever getting a license, which means you only have 2 years left where you can do this, because anyone who writes that letter should not then be allowed a renewal after 2 years. So maybe section 44, Mrs. Gordon-Jones, section 44 needs to be amended. Section 3, 44.3, or somewhere, one of you legal minds, to say that if you wrote to say, and I'm just giving a theoretical scenario, you can make it, you can legalize it, for want of a better phrase. But if you wrote to say you have no intention of getting a license, and you only want to have an authorization to teach, then you can't renew that authorization to teach, because you're opting not to be a teacher for whatever your personal reason is.
Chairman, I wonder if we're not running ahead of ourselves. We're gone to 44. At 12:24 p.m., I thought we were going to just close off up to 27, up to 30, up to 27, and then we take 30 onward at the next meeting. And that would include 43.
If I may, Chair,
go on? Okay, go
in
ahead.
terms of the police record, I think it's still an unsettled position as to whether or not it will be required on a case-by-case basis, or whether everyone is required to provide a police record. So, and in terms of a authorization to teach, I get your point, but the authorization to teach is really there to facilitate those persons who are not qualified as teachers, or they are not registered as teachers. So that is really why the provision for an authorization to teach is there. Right. Based on the provisions of the Act.
Who are these persons who are seeking the authorization to teach? I just want to have an understanding.
For example, if you have a tradesman, or auto mechanic who is really very good, and the garage is right beside your school, you'd like to have him in your classroom to teach, then the school could seek for authorization to teach. Yeah.
I just don't want it to be felt in any way, shape, or form that you have a trained teacher who would be applying for this authorization to teach.
But they can't. There's nothing to stop them from doing it. Is there something in the legislation? So theoretically, we know that they shouldn't be applying for an authorization to teach. But what is in the legislation to actually prevent them from doing so? There is nothing as far as unless there's something I missed. Please.
Okay, so under clause 37, it says, subject to this act, every person who is not a registered teacher or a licensed teacher who teaches or proposes to be an instructor in a school or an educational or other educational setting to which this act applies shall apply in the prescribed form and manner to the council for an authorization to teach.
Say, unless I'm not reading it right, it doesn't say, so if somebody's license is expired, based on the written form here in 37, they can apply for an authorization to teach.
The person would be a registered teacher. So they would have to apply for a license because the registration does not expire.
So registration is a different process and it doesn't expire?
Right.
Okay. All right. So that means there's no loophole if you are a licensed teacher, which means you must have registered beforehand. You can't apply by law to be authorized teacher. Okay.
One other clarification, Dr. Gordon. Under the authorization to teach definition, means the permission to teach, evidenced by certificate. Now, your mechanic that you spoke about next door must have some certification. That's what you're saying? VTDI,
yes, VTDI gives a 3 months.
Just to be clear, because you know you have some mechanic next door that never once go in a classroom.
Yes. So we have a process where such persons can be exposed to the rudiments of the classroom over a 3-month, 4-month period.
Okay. And that's good enough, because we must seek to qualify ourselves, whatever profession that we are in. Change that culture. And that's why that's the difference between being defined as skilled or unskilled.
You want to just finish up the other 2 items? Item 8.
And it reads, Member Brown asks whether we should move away from criminal offenses for practicing without a certificate. Dr. Gordon said, even though in relation to the legal profession, practicing as a lawyer without certification is not a criminal offense, both professions are different. If a lawyer is a bad lawyer, he does not get clients, but a teacher who is not licensed gets clients as a matter of course. And we noted the new provision for Clause 24. I think we ventilated that matter enough.
Yeah.
Should I move to Clause 9, number 9, Chair?
Yes.
In relation to Clause 27E, Member Brown said the provision should be separated into Jamaican citizen, permanent resident status, holds a valid work permit allowing the person to work in Jamaica. I'm taking verbatim from the clause, even though it's noted as foreigner on the document. And it was agreed that we could separate the list for each of the status mentioned. Number 10.
Before we move on, members, you agree on this? To separate into Jamaican citizens, foreigners?
Yes.
All right, carry on, Ms. Gordon-Jones.
Minister, I thought you said we were going to end at 12:30. 10 is going to generate some amount of discussion having to do with police records, etc. And maybe we should reserve that for the next sitting. That's just my proposal. In other words, is this a convenient time?
What I see here is that Dr. Gordon is proposing a more strategic approach, given her personal experience trying to get a police record. Right, Dr. Gordon? Yes, please go ahead so we can finish this.
We'll read it.
Go ahead, Dr. Gordon.
Okay, I'll read number 10. It says, in relation to Clause 30, subsection 4, Member Green opened that the duty to report any misconduct of a teacher should be that of the educational institution. Therefore, we should adopt similar provisions to those suggested by the Teachers' Colleges of Jamaica specified in the matrix. And the response is because the teachers teacher holds a license or authorization to teach provided by the council, it is in the interest of the teacher to inform the council within 14 days of the charge. Should there be a challenge later, the council would have had knowledge of the situation with the teacher.
Just for clarification, what do you mean it is in the interest of the teacher?
There might be a situation where the teacher is right, or there's an explanation from a professional perspective of the action of the teacher.
So only at that time it's in their interest.
In that case, the council would have been aware of the challenge and therefore would take up the teacher's cause. But if that is not done, then the teacher is on his own or her own. So it is in the interest of the teacher to alert the council of any such challenge. And I dare say it is also in other legislations that the teacher ought to make the council aware of any charge.
If the teacher doesn't notify the council, then what happens?
The council, if the teacher needs help, then the council is not engaged with it.
Yeah, but outside of needing help.
Pardon?
Outside of the teacher needing some kind of assistance from the council, if the teacher refuses to notify the council of what happens?
Then nothing happens. The teacher cannot expect any support from the council.
Yeah, but there must be something more than that, though. Because how would they...
If a teacher is charged with an offense...
It's outside of just having the protection of the council, but it is the knowledge of the misconduct that I think is important.
Well, the knowledge of the misconduct will eventually come to the council through the various sources. But if the teacher needs help, then the council is not going to engage with the teacher if the teacher did not inform the council beforehand that the teacher was charged. Maybe it turns out that it's not a criminal offense and it's some other matter. So I have seen in the Scottish legislation and in their revised legislation, it is important for the teacher to inform the council that he or she has been charged with an offense. The council will take no action. It's just information to the council. Yes. Because remember, it's a professional body. So you inform your professional body of a charge. This does not deny the fact that the institution should inform the council, in which case the council has information. But then that is the administrative part, relationship between the council and the institution was about the council and its member, the teacher. Which is why
if you look, sorry, just to help you a bit, Dr. Gorin, tell me if I'm right. If you look at the way it's written here, it's in relation to 34. And it says, without limiting subsection 1, the council shall make it a condition of registration. So the penalty, a license or an authorization to teach. So if you did not report the fact that there's a charge against you, the council has the authority to not grant you either registration or licensure or authorization to teach.
So I don't have an issue with that. But what I'm saying is, you may have instances where a teacher may be charged and convicted, and we don't know about it. So it doesn't come out in the public space.
Because here's where now, later on, where Minister Green made the recommendation that everybody who is applying, he said for a license, but I would like to say also for renewal, must provide a police record. And that's how you will catch it. And I want to add to that, so the record, your recommendation was that when you're applying for a license, I assume you mean a new license. I want to make sure it's new licenses plus renewal. And in addition, if you lived in any other jurisdiction for 6 months or more, you must provide a police record from that jurisdiction as well. And that's not strange for some entities in Jamaica. So anybody who taught, you didn't have to teach, you just lived in a jurisdiction for more than 6 months, and you want to become a registered or licensed teacher in Jamaica, you should also provide a police record from that jurisdiction.
In respect
and I'm
of,
looking through the schedule whether or not, normally in some instances you would have an application form that is depicted in the schedule. And that application form can have these requisite areas that you have to fill out, these particulars that would satisfy these concerns. Have you been, conducted of any offense? Things like that. Yeah. So maybe a consideration could be given that in the schedule we have the outline of what can be contained in an application form.
Or in whatever regulation. Regulations coming, right?
Yeah. In the schedule.
I
Jen, you want to respond to that?
Not really. I think that's more for the draft, though. Whether it would, if you want to set out the application form, I think that's for the ministry and the draft, though, to indicate whether they are at that point where they can put it in the schedule or they would put it in regulation.
All right. Thank you for that guidance.
But do we, Madam Chair, do we agree that police records are needed for, I said, are we agreed that police records are needed?
We're not, no?
Oh, we don't reach there yet? Okay. To your question about how do we,
Members,
the only way is with a police record.
Members, sorry, even though I have the objective of finishing this document, but I recognize that there are members that have to leave. All right, and this sounds like it's going to be a bit involved, huh? Yeah. So, team, we'll pick it up at the next meeting, and also I'm going to ask that we come back with the minutes for the last meeting then as well. Right. So in terms of the next item, next meeting date. Well, yes.
Is it possible, I just take this opportunity to raise this issue. Can we get a confirmation of the next 3 minutes at some point? Because it's very hard when we get our email asking us, do you agree with these 3 dates? And then it takes a long time to confirm and our diaries are all over the place. I would love if we can do a long-term planning.
All right, we do have the next 3 meeting dates. All right, Thursday, November 10. Oh, sorry, my error. Next meeting date is Tuesday, October 25 at 10 a.m. And then future hybrid meeting dates will be Thursday, November 10, Thursday, November 17, Thursday, November 24, all at 10 a.m. Right, so 10, 17, 24, all at 10 a.m. And Tuesday, the 25th of October at 10 a.m. Well, let's complete. Right, Member Hamilton? Let's complete over the next 2 meetings. Yes. All right. Any other business? The meeting stands adjourned.
So moved.
Thank you, Member Hamilton. Yes, thank you, Member Rodriguez. Thank you, all members and legal team. Thank you so much.
Whenever you hear the following tone, the Office of Disaster Preparedness and Emergency Management, ODPEM, will be giving information on an emergency situation affecting the